So, welcome everyone to another CIPIL seminar here at the University of Cambridge. Welcome in that sense virtually to Cambridge. My name is Henning Gross-Ruiz-Kahn. I'm one of the co-directors of the Center for IP and Information Law at the university. And it's my great pleasure today to introduce Professor Estelle Derclaye, who's going to speak on a topic of overlaps. Just a word or two on Estelle. She's a distinguished professor of IP law now at the University of Nottingham. I've met Estelle probably around almost, 15 or more years ago. We've been both doing work on databases, but Estelle since has covered a whole range of issues, and this issue of overlaps is something she's been working on quite a lot, has many sort of relevant publications in this field. Estelle has also done quite important empirical and other work in relation, for example, to databases, has had a lead in a study in 2018 for the EU Commission on the review of the database directive. Estelle has visited in various places, such as not least Berkeley, California, Melbourne, and NUS in Singapore. The topic today, looking at overlaps, is something where I think from what I've seen from Estelle, she's going to look at particular empirical aspects of how litigants are using perhaps overlapping IP rights in order to enforce these rights. And she's looking at data she has compiled in relation to other research with regard to registered and unregistered design rights in the EU member states. So with that, I think I'll just leave it and hand over to Estelle. Estelle, thank you so much for joining us, and we'll look forward to hear from you. Just as a last word from my side, for those who have questions, there's a chat which you, a Q&A, please, a Q&A rather than a chat, a Q&A which you can use, and please post your questions into the Q&A. We'll take them at the end. Estelle is going to speak for around about 40 minutes max, and then we'll have about 20 minutes for questions. So there should be ample of time to discuss then. Without further ado then, Estelle, over to you, and thank you again for joining us.
Thank you very much, Henning, for inviting me, and to CIPIL for inviting me today to talk about this article that that's just been published in the European Law Review this month. And indeed, as Henning was already talking about, it's to do with empirical data that I have gathered from a previous paper in 2019, just looking at design litigation in the member states, how valid they are, how the courts are finding them valid, infringed, etc. But here, with the same data, what I wanted to see is whether the claimants who are using their registered or unregistered design rights when they are litigating in the member states, whether they're using other intellectual property rights, and also either Lavish limitation or risk of confusion, so two of the main in fair competition torts, on top, if you want, to see if they could protect their designs even more. And that is indeed the question of overlaps. So thank you again for inviting me. I'm really happy to be here to talk about this today. So this is the outline of my speech, and this is the reference to the European Law Review paper that I'm going to discuss. It covers far more than what I'm going to be talking about today, because it looks also at whether SMEs are benefiting from the EU legal design framework. But I won't have the time to look at that today. And also I won't have the time to look at all the statistics that I have done with my co-authors of Lavish Church and Angie Stupfler, who are the statisticians part of the team, because there's not enough time today. So I will just pick and choose a few interesting bits and bobs in the article so that you can actually understand a little bit more what the results of the analysis is. So first I will introduce the topic, then I will talk to you very briefly about which methodology I used, we used in this article. And then there will be three different aspects that I will focus on. The first one is how much have the litigants used other intellectual property rights and unfair competition in the member states when they litigate. So I'll look at the extent to which they use copyright, patents, trademark, utility model, unfair competition, And then what I mean by unfair competition is only the two types, so lavish limitation and risk of confusion, not denigration and other unfair competition torts. And I'll explain why. And then the rate of winning on a design right, whatever design right, registered, unregistered, national or community design right, with the rate of winning on another IP right or these two types of unfair competition torts. And then the type of design right claimed and the wins on another IP right and unfair competition, because we also try to drill down to the specific design right, with whether it is, for example, a community unregistered design right that is used, and if it differs, whether if it's a community registered design right or a registered design right at the national level, if the statistics change a little bit. And then I'll conclude. So the first thing that we need to really talk about is, why can intellectual property rights be problematic? Why is it that they can sometimes cause problems? And by intellectual property overlap, so if you want to call them overlapping intellectual property rights, what I mean is really genuine overlaps. And by genuine overlaps, what I mean is that we have two or more, sometimes more than just two intellectual property rights, protecting the same intellectual effort at either the same point in time. So that's what we can call a concurrent or simultaneous overlap. And that would be the same intellectual effort on the same object, of course, because the intellectual effort is materialized, obviously, in an object, be it in 2 dimensions or 3 dimensions. So that's your first type of genuine overlap. Second type is when you have one right, for example, a trademark right, which has expired, and then you want to have another right, so let's say a copyright or reverse or vice versa, a design right that has expired and you want to have a trademark right afterwards. That's a posteriori or subsequent genuine overlap. And then finally, the negative overlaps, like you try to get, let's say, a different type of right or even a lavish limitation instead of your design right. In this particular case, in this study, it would be instead of a design right, because we focused on the design right litigation. So the example of a genuine overlap, to make it a bit more concrete for you, is that you have a trademark, for example, and a design right for the shape of a product. And the trademark is really for the shape. It's not for it's not a word mark, for example, BMW or Mercedes, the word BMW or Mercedes, or the little logo, which is the figurative mark, or the combined word and figurative mark attached to 3D design. So in a specific case would be attached, let's say, to a wheel for a BMW or Mercedes car. Okay, so that's not what we're looking at. We're really looking at the genuine overlap where the trademark is for the shape of the wheel, let's say, and the design right is the same shape of the wheel. These other ones, that you can call them false overlaps, they're not really protecting the same thing, because a word or figurative logo is not the shape of the product which is protected by the design right. So we're not looking at those types of overlaps. We're really looking at the genuine ones. Now, as you know, or you may know from your general knowledge, is that intellectual property rights, they're all different. They have different goals, and normally they have different rules, even if some of them are kind of similar rules. And they've traditionally, especially in international conventions, which dates from the 19th century and a part of the 20th century, been conceived as watertight. So they don't overlap generally. They all have their little area that they cover and they don't overlap. But the problem of overlaps has grown within the last few decades of the 20th century for several reasons. First of all, some intellectual property rights have expanded. So there have been, especially in the EU, for example, and through TRIPS as well, the protection of trademarks has grown. And we have a number of non-conventional trademarks, especially shape marks, which in many countries were not protectable before. So there's been some expansion of some intellectual property rights over time, and because of this expansion, that if you want, the plant is growing over the other plant and is taking over a little bit of the other area of the other intellectual property rights and creating some overlap. Then we also have seen another concurrent phenomenon, is the lowering of the protection threshold. So by that, I mean, for example, originality could have been lowered down in some countries. And so that creates more protection for more copyright works, another example. So lowering the protection thresholds, increasing the amount of overlaps, genuine overlaps happening. Then there are also another phenomenon, is that the purposes, the goals, if you want, of some intellectual property rights have changed. The most notable one is trademarks. Where in the past we just had the origin function of a trademark, which was the main function and only function. And now with the L'Oreal case from the Court of Justice, now we have also the advertising function, the communication function, the investment function of trademarks, which is protected and increases therefore the scope and the goal, the purpose of trademark law, and therefore increases the possibility of genuine overlaps. And then we have obviously created new intellectual property rights. That is very true, especially for the EU. Basic example, the database sui generis right is one of them. And then another yet phenomenon is that lawyers have been, especially litigants, have been trying to exploit the loopholes in the law to create opportunities for the clients to protect their rights in the best way possible. So there's a string of cases, especially those that went up to the Court of Justice, that the Lego case and Phillips and Remington case, all these cases where you had an expired patent, or an expired copyright, and the claimant wanted to use trademarks to carry on the protection. So in a sense, having a subsequent overlap. So that is the phenomenon that the several types of reasons why this phenomenon of genuine overlaps has grown over time. And they are allowed. So the overlapping IP rights are allowed. There's no blanket general rule saying you can't have, if you have a trademark, you can't have a design, or if you have a patent, you can't have a copyright. There's nothing like that. But there are some rules which regulate these overlaps in the EU framework. And I'm just going to concentrate on the EU today, just to be clear. This is design litigation in the EU member states within the EU legal framework, not elsewhere. And the most important of these rules is the Article 7 of the Design Directive and Article 8 of the Design Regulation. It's the same wording, and basically regulating the design patent overlap. And then to say that basically designs that are purely functional shouldn't get protection through a design right. And correspondingly, there's Article 4.1e of the Trademark Directive, and exactly same terms, Article 7.1e of the EU Trademark Regulation, which also try to regulate the overlap between, on the one hand, trademarks and patents. That's 4.1e2. There's also 4.1e1, but it's not relevant here. And then 4.1e3, which tries to regulate the overlap between designs and copyright on the one hand, and trademark on the other hand. This is the exclusion for signs which are exclusively give a substantial value to the good or service that's trying to be registered by the applicant. So the aim of the paper is to really check how often claimants use during litigation additional intellectual property rights and unfair competition. And by unfair competition, I will, in this paper, in this presentation, I will always refer to just lavish limitation and risk of confusion when they're actually litigating on their design rights, and the rate at which they win on these other intellectual property rights as compared to their win or their loss on their design rights. Why did I want to look at that? And my team of statisticians, my co-authors, really, I couldn't have done that without them, to try to figure out statistically how strong the conclusions are. Why? Is because their genuine overlaps can create overprotection. And this is why we have these important rules to try to avoid these issues in Article 7 Design Directive and 4.1e of the Trademark Directive. Why? Because if you have two sets of rules which are different, applying to the same object, the same intellectual effort, you often have a regime clash. A regime clash, for example, in the design regime, you have only 4 exceptions, but in the copyright regime, you have many, many more exceptions. So if the design, because of that, the stricter regime, in my example, design law, will trump the other regime, copyright. So if you have a copyright exception that would apply in copyright law to this particular dispute, but it doesn't apply in design law, then tough. If the design right applies, then it will kill off the exception that would apply in copyright law. That's a problem, and because it creates this overprotection, because you're trying to use the two intellectual property rights to, trump the other regime when you litigate. The other one is also problematic, is if you are winning on several intellectual property rights, and you can have double or triple or quadruple remedies for the same infringement act. So because some courts in some member states give remedies for each infringement, of each intellectual property right. But as we know, if it's a genuine overlap, the infringement act is actually the same. It's corresponding to the same shape or the same two-dimensional logo or thing that is protected by the 2 or 3 intellectual property rights. So that creates overcompensation for the claimant. And there is also the problem that I've already spoken about, is that you can, through a subsequent overlap, extend your intellectual property right over time. So just a very quick example that I will not talk about today, because it's not the overlap, it's not a case which came about in my data application, came afterwards, is the Brompton case. So the Brompton case, and also it was only a litigation on copyright, not on designs. The Brompton case came to the Court of Justice, was decided last year, is dealing with this bike that you have one of the patent drawings there, where you probably know this bike. You've seen some of them by random in the streets, people carrying their bikes maybe in the tube or in public transport, because you can fold it. So there's a mechanism that was protected by patent whereby you could fold this bike in 3 and just carry it, or even put it to stand, so it can actually stand on its own. So it's very practical. And Brompton, which had this patent expired, and then wanted to claim that there was copyright on this bike. And as copyright lasts much, much longer than patents, it marketed the bike here in this particular case. It was the litigation is in Belgium, and then there is a defendant that tried to make the same bike, and this Brompton sued and said, no, you can't do that. I have copyright in the bike, despite the fact that the patent has expired. So trying to basically extend the protection that it had through the patent system via the copyright. And that can be a problem because it reduces competition in the sector, because then if the court, it's back to the national court now, if the Belgian court decides upon remand from the Court of Justice that there is copyright in that shape of the bag, then it will give a very long monopoly to Brompton. And so that reinforces monopolies, and if it's not a monopoly, at least the market power that you already have by definition as an intellectual property right holder. So that's why knowing whether these genuine overlaps actually are existing, are problematic. Are there a lot of them? Are the courts not applying the law properly? Although the law is quite settled now, because we have had some case law from the Court of Justice on these Articles 7 of the Design Directive and 4 of the Trademark Directive and the corresponding ones in the regulations. It's interesting to look at it at the level of the national level. Sorry. So the negative overlaps are also problematic because they can lead to overprotection by compensating the design right holder, or any IP right holder, but in this particular paper, it's the design right holder, when it should not have a compensation at all, because the design should not have normally be protected at all, because it does not fulfill the conditions of the design law framework. Why? Because then you use, generally it's copyright or Lavish Limitation, to try to successfully have a protection through these other rights, because you couldn't have a design. And so that is why this use of Lavish Limitation is really interesting, especially if you lose on your design, whether you can compensate, the courts actually compensate you via a win on the Lavish Limitation basis. Now, we also considered risk of confusion, the other unfair competition tort, because it's interesting, because even if it does not involve a genuine overlap, because the risk of confusion is something on top of just copying or making the design, the object that's protected by the design, we wanted to see the extent of its use as an alternative, if you want, if the claimant did not win on its design right. And obviously in that particular scenario, you have to prove that the defendant is creating confusion, or at least there is a risk of confusion on top. But it's interesting to see I wanted to see if there was also a lot of use of this basis in the member states, and how often the claimants were winning on that basis. Now, something that you need to know is that in the sample, we'll talk about the methodology in a second, in the sample, we could not find any litigated cases in which the claimant used another intellectual property rights or unfair competition in 4 member states, in Croatia, Ireland, Latvia, and Malta, because in these countries, there are really just a handful of cases. I think Latvia, there was only 1, and Malta as well, and Ireland 2, something like that. Croatia, there were a few more cases in the sample overall of design litigation. So it was very likely that we wouldn't have found, that in those cases the claimant wouldn't have used another one. So the sample is the 28 member states, because it includes the UK, the 28 member states minus 4, and also minus Luxembourg, because you couldn't find any cases on design rights in Luxembourg in that period. So it's 28 minus 5, so 23 member states in the sample for this paper. Now, how did we do this? So in very brief, not to spend too much time on this, but so that you understand how we did this, we are looking at decisions, and there are 2,255 decisions in the sample, and not litigations. And there are litigations, there are 1,408 litigations. Why? Because litigations, as you understand, the number is much less, because in a litigation you will have several judgments. So you'll have one judgment, in some litigation just one, is not appealed, but sometimes you will have an appeal and also a Supreme Court judgment, and then back down to the Court of Appeal. So you could have in a litigation 2, 3, or 4 different judgments. And a judgment is not the same as a decision. So just so you understand, by the term judgment, I mean like the document, the entire document that the judge hands down. And inside that document, inside that judgment, you will have several decisions, especially if you are in a situation in this paper, i.e. it's only the litigation where you have a design right or more design rights on which the claimant is litigating, plus at least one other IP right and or the unfair competition, the 2 types of unfair competition basis I've just mentioned. So there are more obviously decisions than judgments, okay? And this is in all these member states courts at all levels, so first instance appeal and Supreme Court, and from October 98 to August 2017, so that gives you around 20 years of data. And why October 1998? Is because, as you may know, this is when the design directive had to be implemented in the member states, and when litigation started to come in the courts, and the design regulation that was just a few years after. So that's why we took those dates. Now the statistics, they are in the paper for all the member states. They're overall, they're aggregated, because for some countries there was not enough to perform inferential statistics, or even for descriptive statistics you wouldn't even be able to say much. I'll give you a few examples in the course of the presentation afterwards. So there were only 2 member states in this particular paper on which we could do some inferential stats. That's France and the Netherlands, because France has had the most litigation in the entire sample, and the Netherlands also had a very high number of litigation. So what we do is descriptive stats. So you just describe the past, what's happened in percentages generally, and then inferential stats. So that's where you have calculus and tests to predict what could happen in the future, and at the stats that we do are at the very at the smallest at the 95% confidence level, or even higher than that, 99% confidence level. That is the standard statistical framework that all good papers should have. Then the inferential statistics concerning the rate of winning an appeal, then you got to be careful that what we did is only look at level 2, so the Court of Appeal or equivalent, and not level 3, because you imagine that the sample for level 3 decisions, so your Supreme Court or highest courts, it's generally very small, so you can't really perform inferential statistics, and not enough Supreme Court or highest court decisions in the field of designs overall, and also per country even less. So you can't really say anything, you can't really do inference statistics on that. And the final caveat about the methodology is that obviously all we've done is looking at the litigation, and the litigation is always the tip of the iceberg. There are plenty of disputes in the field of designs, which surely haven't come to the courts, have been settled. The discussions between lawyers of the two or more parties are kept confidential. And so what we see here is really what probably is also happening behind the scenes in lawyers' offices, but we can't be sure. But it gives you some sort of idea of what's happening there also, where we don't have the data, we can't collect the data because it's not published. So let's start therefore with general overall stats concerning the use overall of the other intellectual property rights and unfair competition basis in general in all the member states. So when you look at all the data over all these member states, the most used bases, not surprisingly, are copyright and Lavish Limitation. So your claimant that has one or more design rights will also add copyright or Lavish Limitation to their claim. So copyright's the most used basis, and then the second is the Lavish Limitation, because they're the most resembling the design right, those that you would feel that you probably would win on those, because they're quite similar in terms of the type of intellectual property right or the type of protection you can get for your design. And although Italy and Germany are very close in numbers of litigation to the Netherlands and France, the proportions of use of copyright and trademark are much lower in Italy and Germany. And we shall see why that's the case a little later on when I drill down to every single intellectual property rights. So the use of patents and utility models is very minimal overall, which wasn't surprising because of especially for patents, because of the exclusions I've just talked to you about. And it's hard to draw conclusions on these IP rights. So for utility models, for example, they were only used as a basis in 4 countries, in the Czech Republic, Slovakia, Portugal, and Spain. And there were 5 wins as opposed to 6 losses in total. So you can't really do much with that kind of data. So let's look at copyright. So the data, as I said, we have the data up to 2017 before the Court of Justice decision in Cofemel, where the Court of Justice ruled that the originality requirement was exactly the same for all copyright works. And so therefore, that's why it's quite interesting to see that there are these differences between member states in that respect. Because some member states were protecting works of applied art, and so 3-dimensional designs by copyright at much stricter conditions, and much stricter conditions with this artistic value criterion, which meant that it was very difficult to protect them by copyright. So copyright, not surprisingly, was substantially used in France in addition to design rights. In just over 50% of the cases, the claimants won on that basis, which was not surprising because France has always been the country of unity of art par excellence. So that meant that if a design was protected, fulfilled the condition of copyright, automatically the court would say the conditions of designs are protected, and vice versa. They don't do that anymore because they can't, because of the EU law framework, which doesn't allow this anymore. But it's not surprising that there's a sort of a tradition that copyright is easily, the conditions for copyright easily fulfilled. And otherwise, copyright was used and so won on substantially less in the other member states. So in the Netherlands, you had 53 wins against 87 losses. In Belgium, 10 against 18. In Denmark, 3 against 11. So you see there's a huge, big discrepancy between the wins and the losses, sometimes as much as twice more losses. Italy 4 against 14, Greece 3 against 7. So you can see a little bit how it looks like. And it was used with some success, but as you can see, the majority of the cases, the big majority of the cases, was rejected. And this is where Germany and Italy come in. In Germany, there was no case in which the claimant won on their copyright. Okay. And Italy also has very few wins, 4 wins. And that's not surprising because, as I said, in Italy and Germany, there was a much higher level of originality, so this artistic value for 3-dimensional work. So it's not surprising that they lost. And in the other member states, copyright was either not used at all, or it was only used in a handful of cases, and mostly the claimant lost. And what's interesting, at the level of appeal, the claimants were more likely to win on appeal, 58.4%, than in first instance, 32.4%. And that's at the 99% confidence level. So it has really made sense for the claimants to appeal their decision on that basis. Whether they lost or won, and they wanted a different outcome, it is better to go in appeal. So how does that fare for patents? And I see that I've already talked about for about 30 minutes, so I will try to maybe skip some slides so that we have time for questions, although maybe we started at 35 past instead of half past. So the interesting things is that patents were only used in 10 member states as a basis. So when you think that there were, what did I say, 24, 25 member states in the sample, that's less than a majority. And there were 44 decisions overall with 13 wins and again 31 losses. So again, not many wins compared to the losses. And I did expect that. So yeah, this is probably due to that exclusion in Article 7 of the Design Directive. So it was expected that the claimants would lose because of it. And there is some evidence of that intuition is confirmed in France, because the sample is small, but you can see that three out of 6 cases they're caught by the exclusion of Article 7 of the Design Directive. One is quite inconclusive, and in the other 2 cases, the patent and the design were not exactly on the same aspects of the product, so they coexisted. There was actually no genuine overlap there. So that's the situation for patents. Now, for trademarks, it's quite interesting because this is reverse. So you have more wins than losses, 50 against 40 overall, again, in all the member states. And in most member states, 11 out of 15 countries where the trademark basis was used in addition of a design, then the claimants won more often than they lost. And overall, in the member states, again, this is the appeal thing, there's been a 52% chance of winning on first instance, against a 59% chance of winning in appeal. So there's not too much of a difference here if you appeal. And you would think, therefore, that the results of these wins is because the signs do not consist exclusively of shapes or the characteristics of the goods necessary to obtain a technical result, or giving substantial value to the goods, which is the exclusion in the Trademark Directive and the regulation. And so therefore you must think that logically the claimants only sue on the basis of trademarks, of the trademark, when they're sure it's valid. But still, I thought that's a very high number of wins considering the exclusions, and also considering the fact, as you will see later, that in the other IP rights, not just copyright and patents, there are more losses. So I thought that is probably due to some inconsistencies in the coding, because we had a team of assistants, each from their specific member states, reading these decisions and coding them. And I checked this for France because we didn't have any more budget to carry on this particular exercise of double checking everything by reading the decisions and translating them and checking every decision very carefully, checking the work of the assistants really in detail. And so I double checked it just for France to see whether my intuition was confirmed. And indeed, the number of decisions involving genuine overlaps decreased. And that's the result of the analysis of these French decisions. So there were 8 decisions where you had a genuine overlap, only 8. And in 5 out of these 8 decisions, the claimants were holding the design and trademarks to this perfume bottle called Le Male, designed by Jean-Paul Gaultier, a famous couturier, haute couture in France. And the courts confirmed actually in these 5 out of 8 decisions the design and the trademark's validity without discussing at all that exclusion concerning shapes giving substantial value to the good in the trademark framework. And so this is bizarre. And I thought, why is that? Yeah, maybe the defendant did not raise the objection. That's probably it, because if the defendant doesn't raise the objection, then the court can't raise it on its own. And indeed, that's what I figured out from my French colleagues, who said, no, in France, a court cannot raise an absolute ground of refusal for a trademark if none of the parties have raised it. And that's probably explained, it doesn't say that in the judgment, but that seems to be the explanation. Same happened in another case concerning another perfume bottle with a genuine overlap again, where the trademark is the shape, as you see, and the design as well. And again, no discussion of the exclusion, but the court says both rights are valid and infringed. Then we have the 7th case that dealt with screw-driving handles, which is a case where the court again held both the design and trademark valid and rejected. Here it applies the functional exclusions in both the trademark and design rights, but it says that they're both valid. And then finally, we had the last one, that's the metal ground anchor. And here the court finds that the functionality exclusion applicable, again, the same exclusions in both rights. Here they apply. And so the court invalidates the design on the basis of Article 8 of the design regulation and restates, in fact, the invalidity of the overlapping trademark, which OHIM, now UIPO, had already decided on the basis of the functionality exclusion in the UTMR. So this is the only one where basically this metal ground anchor where there's no trademark and no design. And so I thought that was quite worrying results. If this is the same in the member states other than France, okay, there could be some inconsistency in coding, but when you are left with the genuine overlaps, there could be similar results than those in France. And at the moment, at the time, I didn't have the budget, but now I do. So what I'm doing is looking at that to see whether there's a similar situation in France than in France in other member states. So they are worrying results because, in effect, the exclusion could or should have probably applied, especially in the Lemao decision, and therefore there's overprotection here, simply because the defendant doesn't raise the issue because they don't have a good lawyer, or they just don't appear. Sometimes they don't come up to the litigation at all. And so the reform would be here to enable the courts to raise these absolute grounds of refusal. Could be a reform at national level, or if possible, by the EU, if this is the competence of the EU. Now, the last two grounds is lavish limitation and risk of confusion. So how many times did the claimant use lavish limitation? A lot. You can see that overall in all the member states, they've used it over 300 times. And there were more losses than wins. And it was only used in 11 member states because there's some member states that don't have lavish limitation at all as a ground. And it was used most heavily in France, and then in the Netherlands, there were 4 member states where the claimants lost more often than won, and in 4 member states, there were claimants won more often than not. And in the Netherlands, the claimant's rate of winning on that basis is smaller than a fifth at the 99% confidence level, whereas in France, it's lower than half. And so it's very difficult, even in France, where lavish limitation has been used a lot, and has been used in the past a lot, to protect any type of intellectual effort. It's difficult to win. And interestingly, here you have different statistics at the level of appeal. So you're most likely to lose more often in appeal than if you are using it that basis at first instance. So that contrasts a lot completely with copyright and trademark, where you are more likely to win in appeal. Here you're less likely. And finally, the risk of confusion. Here again, there are more losses than wins, 55 against 41. Again, it's not used a lot, which I was surprised actually, only used in 10 member states. And here there's a huge difference. If you win in first instance, you have 30% of the cases where you win at first instance against 60% of win in appeal. So overall, again, the 99% confidence level are the more likely to win in appeal. So it's a very powerful tool if you know that the defendant is creating confusion, and you're more likely to win there. So I will go very fast on the last few points because I see it's 6:10, but I wanted to flag up a few things because we found out there was a positive relationship between winning on your design and winning on a design right and winning on another intellectual property right or unfair competition basis. So they go hand in hand, again, at the 99% confidence level. And that is also verified by specific design rights. So overall, with all the design rights together, but also if you use any type of intellectual property rights or unfair competition, i.e. lavish limitation or risk of confusion, and any specific design rights. So these stats are also confirmed at the specific design right. If you just look at community and registered design rights and another IPR or unfair competition, or just a registered design right, for example. And that's really interesting. And so we drilled down to look what was happening in those two countries, as I said, France and the Netherlands, where you had more data to do country analysis. And in France, we found there was a positive relationship between winning on copyright and winning on the community and registered design right. And it appears, therefore, that when a claimant sues on both rights, they're both winning or both losing. And it's the same in the Netherlands as well. So it seems to indicate that basically copyright does not trump the community unregistered design rights, which I thought it might not, yeah, because they are kind of twin brothers, if you want. They're very similar type of protection together. And on the contrary, they go hand in hand, they reinforce each other. So as I said before in the introduction, it's a problem because in France especially, the damages are accumulated. So you get two sets of damages for your copyright infringement and your community unregistered design right infringement. So that creates overprotection. You overcompensate for one single act of infringement. And there is also an interesting point, because when we look at the data, when the claimant litigated on a community registered design right, so that's registered, not unregistered, and copyright, they're more likely to lose on both rights. And you think that's bizarre. Then to win, 33 against 9 decisions. And there are very low numbers, 3 decisions for each when the claimant wins on CRDR, but not copyright, and vice versa. So it seems to indicate that it makes more sense to litigate on you're more likely to win if you litigate on an unregistered design right, because the scope of an unregistered design right is by definition vaguer. If your design is registered, you have a photography or picture of the design at the registry, which is fixed in time. You cannot change it. So the defendant doesn't know about unregistered design right, might not know that you have one, and it might not know what the scope is, what you're going to claim that you have a design right on. And so they're more likely to infringe because they don't know if they're infringing and don't know what the scope is. And so that accumulation between the CUDR and copyright is quite problematic. You don't really need the two together. You need a situation because especially in member states where you're accumulating them, the damages. And so either you don't allow the accumulation at all, at least at the level of infringement, like in section 236 of the UK CDPA, or you allow the overlap, but you don't allow double or triple, etc. Damages to prevent that overprotection. So that leads me to my conclusion, and it's my last slide, that what we found in the article really in doing this research, the most striking finding that's overall claimants have more often lost on another basis. And I think I would include trademarks, because I think I will find that at the end, we have more losses also in trademark because of these inconsistencies. They lost more often on the other basis. And so even though you really have a problem of genuine overlaps, and there is a regulation through the design directive and the trademark, the design directive and the trademark directive and regulations to prevent these genuine overlaps to exist. In fact, the law is quite well tailored. It's already well, interpreted by the Court of Justice, and the national courts apply the law quite well, and therefore this overprotection is rather rare. But nevertheless, it would be really interesting to see if the finding is confirmed at national level, especially this problem that I explained to you about trademarks in France, where the courts don't raise this absolute ground of refusal, and you can actually have overprotection there, even in cases where it shouldn't be the case. And then the second thing is that overall, the claimants have been more successful in appeal, except on Lavish Limitation, compared to first instance, when they use these different IP rights, including risk of confusion. So that, I think, is also problematic, because it disadvantages those who cannot afford large legal fees. And when you think about it, in the field of designs, there's a lot of little small designers, independent designers, and SMEs who might not be able to afford these fees to go and appeal and have the result, the just result that should come out of the case. Especially because the first courts might not be as specialized, not as good, etc. And then you go to the Court of Appeal, has more experience. And finally, my last point is that there is overprotection when the claimant wins on two similar rights. For example, the community unregistered design right and copyright, and the court awards damages for both infringements. And that there should be, I think, some reform in that respect to avoid this overprotection. And that's it. Thank you very much for your attention. I will now, so you have my details, and I will stop sharing and give the floor back to Henning.
Yes, well, thanks a lot, Estelle. That was excellent. A lot of interesting data you presented there. I must say I probably didn't keep track of all details, so I might, if there's time, I might sort of ask you on one or two things. But we do have some questions so far, and I encourage others who have questions to please post them now into the Q&A.